Good evening, everyone. Nice to see your squares. Again, if you don't mind, you're in a place where it is safe and comfortable for you to do so. If you don't mind turning on your camera, it would be appreciated just so we can get a bit more engagement. Thank you for coming this evening. Announcement for the folks who are not in attendance. I wholly understand and appreciate that things come up last minute. If you could attempt to give me a bit more notice, if you will not be in attendance at our Monday meetings, it would be appreciated. We do have external speakers who have committed their time and energy to presenting for us. And while I recognize the recordings are available, there's obviously much more value if you are in attendance. So if the majority of folks will not be in attendance at a certain meeting, I will look into postponing or rescheduling. With that being said, one of our guest speakers has already let me know that they are unavailable. So just pulling up the calendar of events, Sharon Fairley will no longer be available on October 31st. So I'm looking to reschedule that for a later date, as well as identifying an additional speaker. Once I have those revised dates confirmed, I will of course send the group an email, but wanted you all to be aware that information was available to me. While I have the team, before I hand it over to our speaker, wanted to give everyone here some space or time to talk about how their research was going, if they have any questions or concerns or relevant updates that they think would be of value or interest to the rest of the group. Morenike.
Hi, I don't know if y'all can see me. I'm on my iPad. But I just wanted to say my research is going really, really well. I was able to talk to some sheriffs and some police from the 4th precinct and also some members of the community to conduct interviews and find out what they feel like are the biggest hurdles they run into when trying to navigate the legal system. A lot of them didn't realize that, bail bondsmen, you can set up a payment plan with them, or how to contact the bail bondsman, or, you can look somebody up on Docket Master if you believe they've been arrested. So it's been a really good 2 weeks for me conducting those interviews. And now I have navigating questions for my research.
That's awesome. And I'm really picking up some of the enthusiasm that it sounds like you have caught from this research. That's fantastic.
Yeah, it's going really great. I'm super excited. I'm gonna put the questions today that I was asking and the responses into the Slack channel. So if other people want to use them, it'll be available.
Thank you. Thank you for using the Slack channel too. I appreciate you for that. So it doesn't feel like I'm totally talking to myself in that. Appreciate it. I'm very good at talking to myself, let the record show. However, if folks want to add additional things into there, that's always appreciated. I've just put into the chat a reminder of the shared document Excel file that we've been using for updating the research themes as well as your guiding questions. So if and when those evolve, please feel free to update them accordingly. And Ashley, that is a public document. So if it's of interest to you to get more access to what our fellows this term are engaging with, please by all means do so. And with that, anybody else want to share any challenges, moments of success, highlights from the research so far?
I can share. So I decided, not to partner with a specific police department or organization, but I think I've identified a couple individuals who I could speak to and get some insight into the legal training that police in the area get. So I'm working on nailing down those interviews, but it, could be really interesting and really cool. And I'd be grateful for the participation. So I'm excited about that.
Awesome. And I know said it before, and we'll probably continue to say it a million times from Saturday. But if and when I can be of additional support to you, please feel free to reach out. That is what I am here for. But it sounds like some really exciting progress. Is anybody not having any progress, feeling like they want to express some frustrations, areas of concern? That's encouraging. If you would prefer or be more comfortable to do that offline, again, feel free to let me know. Well, with that, I am delighted to have our first external speaker with us today. I shared his bio and the PowerPoint presentation that he'll be using early last week, I believe, so it might be lost in your email. So as a refresher, I'll go ahead and read the bio of our esteemed speaker today. So today we are joined by Captain Ashley Heiberger, who served for 21 years with the Bethlehem in Pennsylvania Police Department, which is an agency of 150 sworn officers. He retired in 2017 as a captain and the Professional Standards Division Commander. He spent 5 years with Rosenbaum and Associates as a senior policy advisor, where he evaluated compliance relating to use of force, policy development, training, and officer accountability pursuant to a federal Department of Justice settlement agreement. He is now a very approachable, very esteemed expert in this space, and part of that reason why I wanted to invite him today. What I've really enjoyed about every conversation that I've had with Ashley is that he has an openness and understanding to a lot of different points of view, in addition to his wealth of expertise in this space. And I thought it was important to also start our external speakership with somebody who has served in the policing capacity as well as in an advisory space. So he sits comfortably within that practical as well as academic environment in a way that I found really fascinating and really challenging to in conversation. It has, I think all of our discussions have flexed my brain in a new and very enjoyable way. So Ashley, thank you so much for being with us on this Monday evening, and I hand the floor to you.
Well, thank you very much. And for the record, I also enjoy our conversations. I definitely feel smarter after speaking with you. So we can go here. Can everyone see that?
Not yet, no.
Okay, Jess, do you have to send me something to, do you have to send me an invitation to share my screen?
No, you should have access at the bottom. I do have it pulled up at the PowerPoint, if that would be of use though. That's gonna be all of the slides.
You're saying you can't see my slides, correct?
Correct, we cannot.
All right. If you're the host, can you send me an invitation to share my screen?
Let me just make you the host. Let's see what that does. With great power comes great responsibility. It's a reminder. That allow any movement? Ah, there we go. Perfect. That's visible.
Great. All right, everyone. I appreciate the invitation from Ms. Walker to join you. And I also appreciate you folks giving up an evening to spend some time talking about force with me. I know how busy everyone is at this point in your career, so I sincerely appreciate you taking time out of your busy schedules. That's where we are. Before we get too deep into this, I would just like to emphasize that nothing I say is legal advice. that handout / student manual with which you've been provided in PDF form is not legal advice. If you want legal advice, you have to ask your lawyer, because that ain't me. My contact information, please feel free to reach out to me. I'm always happy to engage with people from all walks of life about policing issues, even if that's just you contacting me to tell me how wrong I am. We touched on my background very briefly. There it is again in writing. So I think that's a statement that there could be very little disagreement. I think we all recognized what happened on that date. And I also believe that something similar happened, although perhaps much greater significance, happened on that second date. But here's a proposition upon which we can all agree. You saw what I did there, right? The way in which our country looks at force has changed. The way things are evaluated and assessed currently compared to the way just a few years ago, much differently. I'm going to show you a couple lists here in a moment. Just because a particular incident is on the list, it doesn't say that I'm expressing an opinion one way or the other regarding it. It's simply there because I feel it generated some high profile attention. What we have there is a list that covers approximately 2 decades, almost 20 years. There's 6 use of force incidents reflected on that list. I'm fairly certain that unless you had some sort of direct connection to another use of force incident, those are the only use of force incidents that you as an average community member would have been aware. Some of you might not even recognize some of the names on that list. But again, we saw during that roughly 20-year period, there's not a whole lot of national attention paid to use of force incidents. I believe that's because most responses to force during that period were local and isolated. And if we contrast that to the way things have gone over the last couple of years, we can see this list is much more detailed. I'm virtually certain that everyone in this program is either aware of the name of those subjects, they're familiar with the fact pattern, or they would recognize the video if video does exist of the encounter. So starting in 2014, going all the way up through this year. And I believe that that difference is because responses to force today, as opposed to several years ago, are national and coordinated. I believe that's in large part because of the way in which our society now distributes and consumes information, both through traditional and social media. With that increased public attention has come increased community responses. If we take a look at the summer of 2020, immediately after the George Floyd incident, that 3-month period, we saw about 10,700 incidents across the country. Of those, the vast majority were peaceful. However, that 5%, which is roughly 570, were not. They involved property damage and personal injury. We all saw the reports coming from some of those communities. So the increased attention has led to some different community-based responses than we've seen in the past. So what do we need to do when we evaluate force? Well, first thing we need to do is understand that there are several force evaluations, 5 to be exact. The first, and tends to be the most serious, is the criminal standard. Now, I'm fully aware that someone can be charged by federal authorities with criminal conduct relating to use of force. We saw that early on with the Rodney King cops. We saw it again with the Walter Scott case in Charleston, North Charleston, and we saw it again with the cops in Minneapolis. However, typically criminal charges are brought in the state system. The second is the constitutional standard. That's typically litigated in the federal courts. Again, I'm fully aware that you can bring constitutional claims in state court. However, most of the time, plaintiffs' attorneys prefer to be in federal court. Why is that? Well, there's 2 reasons. Number one, there's generally no cap on damages, or I should say the other way. There's typically a cap on damages in state court. There is no cap on damages in federal court. And the plaintiff's attorney can also get their fees paid if they prevail. So for those two reasons, we typically see constitutional claims litigated in federal court. Third, there's the administrative standard, the agency's policy, as we refer to it informally when we talk about a use of force being in policy or out of policy, or an agency might change their policy. What we're referring to there is the agency administrative standard. There's also a community standard, which is obviously informal, although the community standard has become much more influential in recent years. Now, I certainly understand that how much influence the community standard has on the agency's administrative policy depends largely on the community in which the agency is located. That can have very great influence or not so much depending on where you are. And finally, there's an international standard. But again, this is the United States. We generally don't pay a whole lot of attention to the world thinks about us in any respect. So the international standard is not particularly influential. So most of the time we're talking about force evaluation, we're either talking about a state criminal standard, a federal constitutional standard, or an agency administrative standard. And so that leads us to this point. The same use of force can have a much different result under which standard it's being evaluated. Just for example, something could be a constitutional deprivation, not a criminal act, because there's no requirement that a state criminalize conduct by police that would violate the federal constitutional standard. Or something could be a criminal act under a state's crimes code, but not be a constitutional deprivation. One way in which it might be helpful to wrap your mind around that is to think about the use of tasers in New Jersey. When conducted energy weapons, of which taser is the most well-known, started to become more widespread in policing, they weren't allowed to use them in New Jersey the way they were in the rest of the country. And ultimately, they worked out a plan by which the number of tasers allowed to be carried by police was based on the agency's service population. You know, a smaller community was allowed to have fewer tasers out on the street than a larger city. So if we just take that example and massage it a little bit, imagine if the state of New Jersey had outlawed the use of tasers by police. They made taser use a crime. Well, there might be a set of facts in which the taser use was completely reasonable under the Constitution. There was no constitutional violation. However, that officer would have been in violation of the hypothetical criminal law that did not allow them to use tasers. Again, we could also see that something might not be a crime nor a constitutional deprivation, but it still might be a violation of agency policy. In other words, the political leaders, the police leaders, they might get together and say, we are going to set our administrative standard a little bit higher than the criminal law, a little bit higher than the constitutional law, and we're going to set our agency standard at the top. So we can have an officer who uses force in a way that falls outside the agency standard, but yet is not a crime nor a constitutional violation. So whether or not a use of force is justified or not depends under what lens we're viewing it. If you're interested in learning more about that, as well as several other aspects of force, I can strongly recommend this book, Evaluating Police Uses of Force by Seth Stoughton, Jeff Noble, and Jeff Alpert. So we've seen force standards evolve somewhat in the last several years. Has the international standard changed? No, not at all. It's pretty much been what it's always been. And the constitutional standard hasn't changed a whole lot either. There have been some changes. We'll talk about one of those a little bit later in the program, but essentially the constitutional standard has remained what it is. We've seen some moderate change in state standards, particularly in California. I know in 2019, they redid their state criminal statute, among some other changes in other states. But we have seen significant evolution of expectations in both agency standards and community standards. So just to get a sense of what we're talking about in terms of the highest level of force, the deadly force that police use, you can see there a number for each year of fatal officer-involved shootings in the United States. You can see that number starts in 2015. There's a reason for that. Prior to 2015, we gathered that number through voluntary reporting through the FBI. That number typically ranged from about 400 to 500 or so. In 2015, the Washington Post, the media, actually decided to try and get a better handle on that number. And they told us that we were undercounting the actual number of fatal officer-involved shootings by almost a half. You can see that number has hovered around 1,000. Some years it's a few more, some years it's a few less, but that number has generally stayed consistent right around 1,000. I don't think it reflects very well on us as a profession that we have to rely on the media to tell us the number of times an officer exercising police authority shoots and kills someone. Unfortunately, that's where we are. And the number of non-fatal officer-involved shootings has not been determined to any reasonable degree of certainty. There are estimates out there. They're sometimes published in academic papers. They're sometimes mentioned in presentations. And I've talked to several of those people, but they'll be the first ones to acknowledge that they're really just guesses and probably not all that accurate. So again, I don't think that reflects very well on us as a profession, that we don't have a better handle on those numbers. So let's start with the criminal standard. I think we can intuitively understand that some conduct when engaged in by police officers is inherently wrong. It's wrong just simply because it is. An example of that would be robbery. If you're shaking down drug dealers, that's just wrong because it's wrong. However, when we look at the potential criminality of force, we have to keep in mind that force is often a legitimate tool. Police officers are lawfully exercising the authority that we as a community, as a state, as a country have granted them. So when it comes to prosecuting them, it has to be proven that they used force in an illegitimate way. Not simply that they used it, but that they went outside what the law allows, that they exceeded the authority that we've granted them. And since we're in criminal court, that has to be proven beyond a reasonable doubt. And that is very challenging. This is just my take on it. I look at the power to take a human life when justified as sort of the ultimate authority that we provide to police. But the other side of that coin, criminal prosecution for taking someone's life, that's the ultimate penalty for misusing that authority. Our friend Phil Stinson, who has both a JD and a PhD, I don't know about you, but that combination just makes my head hurt. He's the PI down at Bowling Green State of the Police Integrity Research Group. They study police criminality of all kinds. However, he's a great resource on this type of information when it comes to criminal prosecution. Keeping in mind that we have about 1,000 fatal officer-involved shootings every year. And from the beginning of 2005 through June 30th of this year, their numbers tell us that 168 officers were arrested for homicide. I've broken that down a little bit because I found this interesting. If we look at sort of the historic trend from about 2005 through about 2014, we see that we were averaging about 5.4 per year. In what I call the post-Ferguson era, roughly 2015 through 2019, we see that jumped up to over 12 per year. And then if we look at the post-Floyd era from 2020 moving forward, we see that's gone to over 21. Now, I understand that we're looking at a relatively small sample, and I understand all the difficulties that causes. But from a policing perspective, I find those increases fascinating. See the breakdown there per year. Since 2005, there have been 52 convictions. The asterisk is there because even though they were charged with some type of homicide, the crimes of which they were ultimately convicted didn't always reflect that level of seriousness. We see 30 convictions by juries, 21 guilty pleas, probably pursuant to some type of negotiated plea. And we saw one conviction at a bench trial. I'm trying to narrow that down, but that took place somewhere between March of 21 and March of 22. To the best of my knowledge, that was the first time an officer had been convicted of an on-duty use of force by a judge. You can see the breakdown there of those convictions. The last one on that list, that reckless discharge of a firearm, that always struck me as a rather low-level offense for what we're talking about here, but then I wonder if it wasn't included with some other more serious offenses. But again, you can check that list. Regarding the sentencing of officers who were convicted, if we look at the 7 who were convicted of murder, we see the range went from about 6.75 years to life, and the average being about 18.25. For those that were convicted of manslaughter and homicide, that range went from 0 to 40 years, with that average being about 5.2 years. With the non-convictions, you can see there we saw 30 jury trials acquitted. Run through that list. So the status of criminal prosecution through the end of June of this year, we had 168 officers charged, 52 convictions, 58 non-convictions, and another 58 still in the pipe. Moving on, let's talk about the constitutional standard. We know the US Constitution has been around since 1788, and it's been effective since September 25th of 1789. I'm not talking ratification, I'm talking about effective date. There's the most important words for our purposes in the Fourth Amendment that we're talking about: protections against unreasonable seizures. We all know at this point in our careers that the Fourth Amendment regulates seizures. And the way that plays out in the force arena is that if a set of facts, if an incident, if an occurrence does not meet the standard of a seizure, the Fourth Amendment isn't implicated. That's not necessarily dispositive, because there can be a whole lot of other things still going on as a result of that incident. But if there's no seizure, there's no Fourth Amendment implication. You know, typically we see the constitutional standard applying in the vast number of cases in terms of a civil suit. One person is suing a police officer or a law enforcement agency. A much smaller number involves the federal criminal prosecution of an officer for violating the federal constitutional standard. And the very smallest group is a civil suit by the United States Department of Justice against an agency. So that's not to scale, but I wanted to kind of give you an idea to sort of illustrate the number of times the constitutional standard applies in a civil suit by a private party, as opposed to federal criminal prosecution or a civil suit against an agency by the Department of Justice. So it's not to scale, but you get the picture. So again, most of the time, it's a civil suit brought by a private party under the federal statute that enables this, Title 18 of the United States Code, Section 1983. If you've been around this at all, you've sometimes heard people talk about 1983 suits. 1983 suits represent a civil action for deprivation of rights. Keep in mind that Section 1983 doesn't create any new rights. It's simply the mechanism or the means by which you get into federal court if you feel your rights have been violated by a state actor. For federal criminal prosecution of an officer, that's also in Title 18 United States Code, Section 242. That's called deprivation of rights under color of law. Again, we saw that in '93 with the Rodney King cops, more recently with Michael Slager in North Carolina, and this year with the George Floyd cops and the Breonna Taylor cops. And finally, we have the constitutional standard applying in a civil suit brought by the United States Department of Justice against a law enforcement agency. In the 1994 crime bill, they codified Title 42, Section 14141. That has now been recodified at Title 34 of the United States Code, Section 12601. But again, those of us that have been around a while, we like to say 14141 because it just has a ring to it. It's kind of catchy. So I will tell you, you can just call it the former Section 14141 and you'll be good. That's known as the Law Enforcement Misconduct Statute or the Pattern or Practice Statute. That's the federal law that gives the Civil Rights Division of the United States Department of Justice the ability to investigate a police department for a pattern or practice of constitutional violations. At the conclusion of that investigation, if their findings indicate such a pattern or practice, the United States Department of Justice actually files a civil suit in federal court against the municipality to take control of the agency. Now, no one really wants that outcome. The feds don't want to be running municipal police departments. Municipal police departments don't want to be run by the feds. So what they do is they engage in what's called a consent decree, because the agency is literally consenting to the oversight by the Department of Justice, or a settlement agreement. We saw that happen for the very first time in Pittsburgh, Pennsylvania in 1997, followed by the New Jersey State Police in 99 and the LAPD in 2000. More recently, we saw Seattle, New Orleans, and Baltimore. So let's talk about the constitutional standard as it relates to force. The United States Supreme Court set forth their standard on deadly force, which is a seizure of a fleeing subject in a 1985 case called Tennessee versus Garner. So let's take a quick walk through the facts of Garner. I think they're helpful. On the night of October 3rd, 1974, the Memphis Police Department got a call about a potential burglary. They were called by a woman who said, "Nobody should be home next door. I hear what sounds like glass breaking. I think someone is trying to break in." So the officers arrive, two of them. One goes to the front, one goes around to the side of the house to get a view of the backyard. And the officer who went around the side, he sees a figure running across the yard. He illuminates the figure with his flashlight, and he believes it's someone who's about 17 or 18 years old, and he's reasonably sure they are not armed. He gives commands for the subject to halt. The subject continues to run. The subject gets to a 6-foot fence at the end of the backyard. The officer again gives a command to halt. The subject starts preparing to climb the fence. The officer figured, probably correctly, that if the subject made it over the fence, he'd got gone, and that would be the end of it. So as the subject started climbing the fence, the officer drew his handgun and fired. One of the rounds struck the subject in the back of the head, and 15-year-old Edward Garner died on the operating table. Now, with our modern mindset, that sounds completely crazy, but we have to bear in mind that in 1974, that shooting was justified under Memphis Police Department policy, the administrative standard, as well as Tennessee state law, the criminal standard. Clearly, that didn't sit too well with Garner's family. They filed a federal civil rights lawsuit that wound its way through the system until in 1985, the Supreme Court delivered its ruling, which remains the state of the law today. And that is that police are not authorized to use deadly force against a fleeing subject unless that fleeing subject poses an immediate threat to the safety of the officer or others. In other words, deadly force cannot be used solely to prevent escape. And that remains the state of the constitutional law even to this day. The United States Supreme Court ruled on force once again just 4 years later in a case called Graham versus Connor addressed force more generally within the context of an arrest, a stop, or other seizure, and talked about reasonableness. The facts of Graham are interesting as well. DeThorne Graham was a Black man who lived in Charlotte, North Carolina. He was employed by the North Carolina Department of Transportation as a patch crew foreman. He supervised a crew of men that filled potholes on the highways. On the morning of November 12th, 1984, he was at home tinkering around with an automatic transmission when he felt a diabetic episode coming on. He felt his sugar dropping. So he called a friend of his, a man named William Berry, and asked Berry if he would take him to a nearby Pilot convenience store so he could get some orange juice. Now, Berry, being a good friend, he was concerned about Graham, so he probably drove there a little faster than he should have, pulled into the parking lot a little carelessly, parked askance, and Graham jumped out, ran into the convenience store, picked up a container of orange juice, got in line to pay for it. He saw there were several people in line ahead of him, realized he might be waiting there, decided he didn't want to wait. He set down the orange juice, ran back out of the convenience store, jumped into Barry's car, and Graham asked Barry to take him to another friend's house. So again, Barry, he's caught up in the urgency of the situation. He probably pulls out of the parking lot a little faster than he should have, and probably drives away a little faster than he should have as well. Now, with us having the benefit of that information, we understand that that sounds, pretty typical. However, if you're Charlotte police officer M.S. Connor and you watch that unfold from across the street, what do you think you saw? You think you saw a robbery. So Connor stops Barry's car about a half a mile away, I believe, And that stop did not go well for DeThorne Graham. He had several injuries, and he received medical treatment for about 5 weeks after that incident. And he too filed a lawsuit and made its way through the system until the United States Supreme Court gave us its decision in Graham versus Connor in 1989. And this is kind of interesting what the court did in Graham versus Connor, because typically when appellate courts rule on police use of force, it's a straight thumbs up or thumbs down. Yes, that was justified. No, it was not. But in Graham, they went one step further. They essentially said, hey, law enforcement, pay attention to this, because we are going to tell you exactly how we are going to evaluate your use of force from here going forward. And they did that by way of providing us with what are known as the Graham factors. They evaluate the severity of the crime at issue, the threat to the safety of the officer or others, and whether the subject was actively resisting arrest or attempting to evade arrest by flight. Those are the Graham factors. Now, you will typically hear law professors, legal commentators, those types of folks talk about the 3 Graham factors. They're certainly correct. They group everything after actively as one factor. I prefer to break it down into 5, as you can see on that slide, because that gives you the acronym of STARE. I didn't create that, but once I learned it, I found it very helpful. When I was a police officer using force, I had to write reports, documenting what occurred, and I found that very helpful to make sure all the required information was contained in my report. Later, when I became a supervisor and I was responsible for evaluating the reports written by other officers documenting their use of force, I found it also very helpful to make sure that they had all the required information in their reports. So now you too have STARE. I give that to you at no additional charge. Let's look at the Graham factors in a little more detail. With the severity of the crime at issue, we're not talking most times about the initial crime. In other words, why the police first became involved. We have to look at the most serious crime that's involved for our analysis of this factor. Let's say that officers are dealing with someone who's suspected of shoplifting. I believe that's been termed as the pettiest of petty offenses. But certainly things get much more serious if that retail theft subject draws a firearm. So we have to ensure that we're assessing the most serious crime during the encounter, which is not necessarily the initial crime. Threat, when we're working our way through threat, we have to look at ability, opportunity, intent. We have to have all 3 present to be a threat. You can have 2 and you can have danger, or you can have risk, but in order to have threat, you need all 3, ability, opportunity, and intent. Graham tells us that the reasonableness of force has to be judged from the perspective of the officer on the scene rather than with 20/20 hindsight. There's a great deal of misunderstanding in certain quarters about this. People have interpreted that to mean as we don't evaluate officers' performance. They say you can't Monday morning quarterback the cop in the moment. Well, that's not exactly true. That's what we're supposed to be doing, is evaluating officer performance. What that 20/20 hindsight prohibition means is that we don't take information or knowledge gained after the fact and impute it to the officer in the moment. We have to assess left to right. In other words, you have the incident and moving to the left, everything that occurred before it. We have to follow the officer as they move from left to right towards the incident, not what we know after the fact, in other words, to the right. Another case that has implications due to nature of Fourth Amendment implications regarding seizures. Torres versus Madrid, it just came out last year. In fact, it hasn't even been fully reported. And that expanded the definition of seizure. So what happened in Torres versus Madrid was that the New Mexico State Police had an arrest warrant on the morning of July 15th, 2014. They were in Albuquerque and they approached Roxanne Torres, who was standing outside her Toyota FJ speaking with a friend. The New Mexico State Police agents knew that Roxanne Torres and the companion were not the person named in the warrant. They just wanted to ask them some questions. For whatever reason, Roxanne Torres thought that they were going to carjack her. So she got back into her FJ and attempted to leave the scene. The officers perceived a threat. They fired 13 times. They struck her twice. Torres drove a short way away. She stopped. She asked a bystander to report a potential carjacking. She left her FJ. She stole a Kia Soul. She drove 75 miles from Albuquerque to Grants, New Mexico, where she sought medical treatment for the 2 gunshot wounds. Unfortunately for her, the hospital in Grants, New Mexico was unable to treat that level of injury, so they airlifted her back to Albuquerque, where she was promptly arrested. But the decision that came down in Torres versus Madrid is that the application of physical force to the body of a person with intent to restrain is a seizure, even if the force does not succeed in subduing the person. The old definition required that there be a termination of movement through means intentionally applied. You can see now, if a seizure can occur even if the person is not subdued, we have increased the universe of events that fall under seizures, and thus broadening the number of incidents that can have fourth implications. That's pretty significant expansion. We've talked a little bit here about black letter law. Now I'd like to talk to you about some things that I think you should be aware of as you sort of navigate the force universe. Is that we're hearing more and more lately about the duty to intervene. And that simply means that all officers, and I emphasize not only supervisors, every police officer has an affirmative duty to intervene if they see someone's rights being violated by their officers. The United States Department of Justice put that on their website in February of 2019. I bolded the word prosecuted to emphasize that we're not talking about an agency policy violation where someone might get a couple of days off or terminated in the worst case scenario, or a constitutional deprivation where, you know, an insurance company writes a check. I'm talking about a police officer being a criminal defendant in federal court with a strong possibility of being incarcerated if they're convicted. The Department of Justice takes this very seriously. You can see that they updated that, provided even more information a short time later. Again, I emphasize with bolding, prosecuted and prosecute. We've been hearing a lot more about this duty to intervene since the George Floyd case, but it's not new. It's been around for a while. In 2000, the 11th Circuit handed down a case called Priester versus City of Riviera Beach. And in that decision, they were evaluating a 1994 incident, trying to figure out whether the duty to intervene was established at that time. In that decision, they quoted an earlier decision from 1986, which made it clear. And that decision quoted one dating back to 1972. Different circuits, because the 72 case came from the 7th Circuit, but still, it made it into the 11th Circuit case. What we had here was, in 2000, a court is saying, hey, we're telling you in 2000 that you should have known in 94 because we told you in 86, and when we told you in 86, we used a reference from 72. So look at those dates. What do those dates tell us? They tell us that that duty has been around since 1972. That's 50 years, 5 decades. So I don't think it's plausible that anyone working as a cop today is unaware of their duty to intervene. How do they establish that? The 7th Circuit's got a pattern jury instruction that I think is very concise. Excessive force. Second officer knew that the excessive force was being used. He had a reasonable opportunity to prevent it, failed to take reasonable steps to prevent it, and that failure caused harm. If we unpack this a little bit, what are we talking about? A realistic opportunity to intervene. I think one of the factors that we're going to see evaluated pretty deeply here is the duration of the force. Is it just like an extra kick or a punch that the subject didn't deserve? Or are we talking about a protracted beating? I think that's going to be a key. Another aspect of this is the reasonable steps to intervene. Here, I think it's going to be the level of force. If you're talking about, you know, just preventing someone from punching or kicking a hypothetical handcuffed subject, or are courts really going to expect you to step in front of the muzzle of another officer's weapon? I don't think so. My crystal ball could be cracked. I think it's going to be based on, or at least relate to significantly, the level of force involved when they're evaluating what's a reasonable step to intervene. We saw this in the George Floyd case. Here's my point about that. I believe the George Floyd case was an outlier. I think that fact pattern is very, very far removed from the types of excessive force cases that we typically see. And since it is an outlier, I don't think it's particularly helpful as far as illustrating to us what exactly constitutes a failure to intervene. So let's look a little more closely. Let's see what's going on in Colorado. In June of 2020, Colorado criminalized the failure to intervene. They made it a misdemeanor and they said, if you're convicted, you can't be an officer in Colorado. Well, about a year later, in Aurora, 2 officers, Halbert and Martinez, they arrested a guy named Carl Vinson. They used some force on him. Vinson got thumped pretty good. A couple days later, Halbert gets charged with a laundry list that included some felonies. But interestingly enough, Martinez was also charged with failure to intervene and failure to report. We roll around to the spring of the following year, and now former Officer Martinez, because she'd been terminated by Aurora, she files a motion to dismiss. She says the law is void for vagueness because the statute doesn't talk about what it means to intervene, and Colorado Post doesn't tell you either. So she argues that that failure didn't give her fair notice, and without that fair notice of what is unlawful conduct, the law is unconstitutionally vague. They have not yet issued a ruling on her motion, but that might be something to keep an eye on. I think that'll tell us a lot, at least what the Colorado court's view is going to be. How do agencies handle this idea of peer intervention? Well, a good example is the EPIC program in New Orleans. EPIC is an acronym. An acronym for Ethical Policing is Courageous. Now, for those of you who maybe know a little bit about policing, you realize that for many years, New Orleans was a very trained agency. And they were really trying to turn themselves around, and they've made tremendous progress. But one of the areas that they realized they were having some difficulty was this idea of peer intervention. And what they did was, with the EPIC program, they changed the focus because they sort of intuitively understood that police were rather reluctant to extend themselves for someone who was perceived to be a drug dealer, who was perceived to be a gangbanger, who was perceived to be something negative. So what they did was they sort of removed the subject from the equation. They said, don't worry about the subject. It's not about them. This is about your loyalty to your brother or sister officer. If you see your partner about to do something that could cost him or her their job or their freedom, your loyalty to them should compel you to act. This emphasis on active bystandership in EPIC is focused on saving your partner's career. And it worked. They got buy-in from the rank and file officers in New Orleans. And it became so successful that Christy Lopez, who was the Department of Justice lawyer involved in the New Orleans consent decree, and Jonathan Aroni, who was the monitor in the New Orleans consent decree, they collaborated. They built upon the work of EPIC. They added in some stuff from the noted psychologist Irvin Staub, and they developed Project ABLE. ABLE is an acronym for Active Bystandership for Law Enforcement. And their goal is to take the 8-hour ABLE training to every police officer in the country at no charge to the officer or the agency. They've generated a lot of money. They've done a lot of training, but there's still a lot more money needs to be generated. A lot more training needs to be held, but they're making significant progress. So keep an eye on Project ABLE. I know we're here tonight talking about use of force, and that's where most of the attention has been regarding the duty to intervene. But keep in mind that that applies to any constitutional deprivation, most likely going to arise at some point within the context of unlawful detention or false arrest as well. Another thing which I think you should be familiar is this idea of a force continuum. Force continuum is a graphic representation. It's a visual that's designed to guide officers' responses to threats based on the subject's actions. You know, force has to be proportional to the threat. As the threat increases, the force can increase. As the threat decreases, the force must also decrease. There's a nice pretty one with a lot of colors. That one's from Albany, New York. You can see the officer's perception of threat. Another way of saying that is the subject's actions on the left and the officer's responses on the right. The problem with this type of continuum is that it sometimes creates the mistaken impression that an officer must hit every step on the staircase or every rung on the ladder. So the force continuum evolved into sort of a wheel model to demonstrate that the threat can come in at any level and the officer can respond at any reasonable level without having to go through any potential levels in between. Here's my thought on the force continuum. And I've probably looked at literally 200 of these in my career. I feel that the force continuum should not be an absolute directive or policy. In other words, the force continuum should not be your agency administrative standard. And sometimes that raises eyebrows. But hear me out on this. I've looked at about 200 of these, and every single one has said that if a subject is an assailant, if they're attacking an officer, a reasonable response to that is the use of an impact weapon. And as far as that goes, that sounds pretty reasonable. It means that if someone, is attacking you, you can strike them with a baton. Again, on the surface, that sounds fine. But here's why we don't want to speak in such absolute terms with our agency administrative standard. Consider this type of situation. You have a police officer in your community. He's male. He's 25 years old. He's 5'10" and he weighs 190 pounds. He's assigned to keep an eye on a demonstration taking place in the downtown area of your community. Doesn't matter what it's for, what it's against, why the people are demonstrating. Just know that a significant number of people are exercising their First Amendment rights downtown. And this officer is down there and he very politely asks one of the demonstrators to make sure she remains on the sidewalk because he doesn't want her impeding traffic or possibly getting struck by a vehicle. This demonstrator, let's say she's female, let's say she's 65 years old. To borrow a line from Rudy, she's 5'0" and she's 100 and nothing. And she's so caught up in the spirit of this demonstration that she kind of takes leave of her senses and she starts trying to slap the officer. Well, under a technical reading of the use of force continuum, she has become an assailant and it would be justified in using an impact weapon against her. I, however, disagree. I don't think an objectively reasonable response under the totality of those circumstances is the use of an impact weapon. Keep in mind that our goal is always the objectively reasonable use of force, which is the constitutional standard that remains in place under Graham. My suggestion is that the force continuum should be a training tool to give officers an idea of what kind of force is likely to be found objectively reasonable under similar. 8 can't wait. I don't know if some of you are familiar with 8 can't wait. It was a list of 8 recommendations put out by Campaign Zero, which was an advocacy group that had the goal of bringing the number of police-involved deaths down to 0. I don't necessarily disagree with a lot of what they had to say. I think they just need some tweaking. For example, their first recommendation was that neck restraints be banned. And I fully agree that neck restraint should not be a tool of first response. However, if a situation calls for deadly force, you do have the ability to use, or you should have the ability to use a neck restraint if that option is available to you. In other words, it shouldn't be an everyday tool in your toolbox. You shouldn't be interfering with people's respirations through neck restraints unless deadly force is justified. Requiring de-escalation, we'll talk about de-escalation in a moment. I think de-escalation is a very useful tool in policing. We just have to be aware of some of its caveats. Requiring a warning before shooting, I think that's a very, very good idea. It's been constitutionally required for decades, if feasible. I think we have to take note that sometimes warnings are not feasible. The same with exhaustion of all alternatives before shooting. If you can safely avoid the use of deadly force, certainly that's admirable, but sometimes the circumstances don't give you that ability. The duty to intervene, we just talked about that. We're not going to put that horse any longer. A ban on shooting at moving vehicles. This is nothing new. The New York City Police Department, I believe it was 1972 when they put that into place. However, I think it just needs to be tweaked a little bit in that we're starting to see, unfortunately, the use of vehicles as weapons in ramming attacks. Fortunately, there have only been a couple here in the United States. Unfortunately, you see more of those in Europe, but I think we do have to allow for the possibility that might occur. So a blanket ban, I think, is unworkable. It can be discouraged, but I think you do need a little bit of wiggle room in the case of a vehicle ramming attack. We just talked about my perspective on the use of force continuum. I believe it should be a training tool, not necessarily your agency policy. And comprehensive reporting, I'm a fan of that. I think that it should be done both in the agency level. In other words, when an officer uses force, it has to be reported to the agency. The agency investigates it to ensure that it was objectively reasonable and consistent with policy and training. And also, agencies should be reporting up the chain, most likely to some state agency that aggregates the data and then reports it to the FBI. We talked earlier about the shameful state of data collection as it relates to force in this country today. A big change that kind of came out, or a kind of big change that came out in the spring of last year. We always were taught to shoot center of mass to stop the threat. In Georgia brought in the shoot to incapacitate training. I've bolded some things there that I think are particularly telling. Challenging decades of police orthodoxy around the use of deadly force. I think that's an understatement. First of its kind in Georgia, could well be a first in the nation. Absolutely. Generations of American law enforcement training. Again, understatement. So we talk about this idea of shooting to incapacitate rather than shooting to stop the threat. And I think that's a laudable goal. But what's the concern that comes to mind? I can tell you that the first concern that pops into my head are the limitations of human performance under the stress of a critical incident, and how that affects officer accuracy. So we look to Donner and Popovich from Loyola with their study in 2018. There's a lot of good information in this study. They tell us that agencies started paying attention to hit rates in the 70s, and in the big departments, those ranged from 22 to 52%. So they went and looked at the Dallas Police Department. They got data from Dallas from 2003 through 17. Now keep in mind that the Dallas Police Department changed over those years. They went from about 3,600 sworn down to about 3,000. But the researchers found 231 officer-involved shootings. They broke that down further to 149 that involved a single officer and a single subject. They found in those 149 officer-involved shootings, 354 rounds were fired. 35% of the total rounds struck the subject. 54% struck the subject once. They also found that one officer fired 23 rounds and all missed. Now, at first blush, that might sound funny, up until it's not, because that means that 23 rounds went somewhere that the officer did not intend for them to go. Some other points from that study, again, keeping in mind it's a relatively small sample size, so we can't generalize out too far, but we saw that Black subjects were significantly less likely to be hit than white subjects. Non-white officers were less likely to be accurate. Last two, these seem to make sense, that officers shot better in daylight and they shot better when the subjects were not shooting back. Another useful resource was the RAND study from 2008, Bernie Rotzker. Now, this is a very large work. There's a lot of other information about firearms training and firearms discharges in there. I went to it only to pull out the information that I'm about to discuss. But if you're interested in this, that's a very valuable resource as well. They looked at the NYPD from 99 to 06, and we know the NYPD was about 37,000 during that period. They found 1,332 discharges. The hit rates, 37% at 7 yards or less. But once they started getting out a little further, they saw that drop to about 23. When the subjects were not returning fire, the hit rate was about 30%, and that dropped down to about 18% when the subjects were shooting back. So I think both in terms of the hit rates as we look using through distance, as well as the gunfight scenario, I think both of those make sense. We also saw a couple more statistics that it looked like close to the end of 2017, they were about 44%, and in 2016, they've been at 35%. Again, all of us, police leaders, elected officials, community members, we have to be cognizant of the practical limits of human performance and keep our expectations reasonable. talk about de-escalation here, but I'm going to throw out my 3 caveats here. I'm a big fan of de-escalation. I think it's a great tool to have in the police toolbox. We also have to recognize these points, those being that it's not appropriate for every police situation, should be attempted only when it's feasible, and it should not be attempted when there's active aggression or a deadly force threat. In other words, if your officers are standing on the porch of a residence and they hear an active domestic dispute going on, someone is being physically assaulted, they make entry and they see one person has their hands around another person's throat, that's not the time to attempt de-escalation. That's the time to use objectively reasonable force to protect life. So that's the de-escalation definition from the International Association of Chiefs of Police. I think they get paid by the word. That's the Department of Justice definition. I think they're not much better. That is a practical de-escalation definition. A deliberate attempt to reduce the necessity or intensity of force to resolve confrontation. I think that's very concise. I think it's very practical. You can have that at no additional charge. Keep in mind that we talk about de-escalation, we're talking about concepts. We're not talking about a specific procedure or a sequential procedure where you do step 1, step 2, step 3. It's not that way. It's a process. Each of the techniques are tools, and you use different tools for different jobs. You know, one of the primary concepts of de-escalation is this idea that when you can do so safely, you want to take a step back, slow things down, reassess, meaning think, and then go back in once you're a little calmer or have assembled more resources. We didn't call it de-escalation, but good cops have been doing this for years. You know, Surar tells us 90% of it is proper patrol tactics. I mean, I went to the police academy in 1995, which was the last century. And they were teaching these types of things there as basic patrol tactics. So again, de-escalation generally is not new. Good officers and good agencies have been following these concepts and principles for decades. We just didn't call it de-escalation. Seth Stoughton, if you remember him from the book that we mentioned earlier, he says the single most important tactical concept is time. And that makes sense. I mean, just think about that in your own personal life as a person living in the world. Sometimes you have the ability to think about a decision. Sometimes you just have to act. Well, under what circumstances do you usually make better decisions? I would say it's when you've had a little time to think. De-escalation skill, active listening is a huge part of it. It's fundamental. It's very basic, but it's work. It's hard work. It's easier. It's more difficult than it sounds when you're trying to understand not only somebody's message, but the underlying emotions. There's some sample policy language about de-escalation from the IACP. Again, I think they're a little wordy. That's what I use with my client agencies. Again, from me to you at no additional charge. Keeping an eye on what's going on with de-escalation, Senator Cornyn from Texas, earlier this year, he introduced legislation that would focus on de-escalation training, partnerships, and evaluations. He talked about putting some fairly serious money into that. They're looking at appropriating $3 million, $20 million, $10 million, and $1 million over the course of 4 fiscal years. It was passed by the Senate in August. It's been in the House since August 2nd. There has not been any activity of which I'm aware to this point, but that's something to keep an eye on there. So that's all I have to say at this point. I understand we might have some questions.
Ashley, that was a whirlwind of information. Thank you so much for flying through all of that. I am looking at the chat and I see a question first from Shelby that was a while back. Shelby, do you want to pose that to Ashley?
Yes, thank you. Let me get the statute, but I was wondering, in one of my classes right now, we're talking about the DOJ investigation into the Missoula, Montana local police department and DA's office and University Police Department on their inability or just ineffective policies under sexual assault. And I was wondering if the statute you were discussing, I wrote it down, the one that's been recoded was what the DOJ was investigating under, but I believe it was, because in your later slide after that, you mentioned that New Orleans was under investigation under that statute. And I'm from Louisiana. I'm in Baton Rouge for law school now. So I'm pretty sure that that's the same issue or same statute.
I don't know absolutely, so I'm gonna take this with a grain of salt. I believe that it would, because that statute authorizes them to investigate constitutional deprivations, and I believe that that might be the same route that they took to that goal in Montana. I can't say for certain because obviously I'm more focused on typically the force side, but I think you're correct.
Yes, sir, I think so, because the constitutional deprivation was equal protection under the law for women complaining to officers about sexual assault that was never followed through. So I'm pretty sure that's what it was, but thank you.
And for what it's worth, I think John Krakauer wrote a book about that, didn't he?
Hannah?
Yes.
Hi. Thank you for your presentation. So I was wondering, how do you feel about proposals to limit interaction between police and the public in general, like sending out different kinds of specialized teams in place of police? I know from your perspective, force is often necessary. So, would it be helpful to just avoid people's perceptions of police and kind of institute a different relationship between government response and the public?
Well, Hannah, you opened up a whole can of worms, and I'm going to talk a lot about this. But before I do so, do you know David Harris?
I do. Yes.
Yes.
He's my professor.
Well, please give him my regards.
I will.
But to your question, and I'm going to kind of break it up and respond to different aspects of it in different ways, if I may. But to what I think is your larger question, every street cop that I have ever talked to about this issue has been in favor of this type of differential response or co-response, because you're essentially saying to them, hey, how about we bring in some people who have more education, more training, more practical experience in dealing with these types of situations, and their presence is likely to reduce the need for force. Street cops are all for that. Street cops are all for that. We've seen success. I think the Cahoots program in Oregon, I think, is one of the oldest, and they've been doing that for probably 30 years, sending out crisis workers rather than police, or sending crisis workers with police nearby. And I believe there are some other ones. I apologize, I don't have them at my fingertips, but I believe that there are several other communities across the country that are taking this idea and getting what seems to be a better result by sending crisis workers rather than police to certain situations. And again, like I said, I think, at least in my personal experience, and I know that's just anecdotal, I think a lot of line officers are in favor of getting that assistance from people with more specific education, training, and experience. Now, as to your other question about just sort of reducing police community contact, I believe Pittsburgh has an ordinance that said certain violations of the vehicle code would not be justification to stop cars under your local policy. Is that correct? I know Philadelphia and Pittsburgh both have similar ordinances.
I actually don't know, but I can check.
And I think, I guess this goes to a larger philosophical question. And I think on some level, communities across the country are wrestling with this. I mean, what is the proper role of police? What do we expect from our cops? Some communities are certainly much more law enforcement oriented. Some leans more towards policing. And one thing I think we all have to keep in mind is that policing in America is a hyper-local function. Hyper-local function. I'm sure you see it. I don't know if you're from the Pittsburgh area, but Allegheny County, how many municipalities do they have there? 130. And how many police departments do they have? Like 128. And so you can have one police department that has one particular orientation, one particular culture, one particular personality, if you will, that's completely different than their colleagues, right across a boundary, because that's either what those particular communities want or what those particular communities have allowed to happen. They've allowed the police to operate in a certain way. So again, I think that's really what that all comes down to, is what does a particular community think that good policing looks like to them?
Thank you.
What other questions or comments did this presentation elicit from the group? And I'd like to reiterate one thing that I've really appreciated in all of my previous conversations with Ashley is his openness to people of differing opinions. And there were a few opinions presented in this conversation. I'm curious if there's any that you disagreed with that you'd like to use this time to express. Deidre.
Thank you for the presentation. I have to say that much of the information was very triggering for me as an African-American woman, because respectfully, a lot of it sounds more like theory than what actually happens in my community. We have all of these laws that say this is what police officers are supposed to do. And I am a non-traditional student. I am in my 40s, and I simply have not seen it work this way. For me, 9 times out of 10, what I see is, well, we have these laws that say that police have a duty to intervene, but at the same time, you have this blue wall of silence. You have a Second Amendment that says that, citizens have a right to carry, but if a police officer thinks that an African-American might be armed, they are gunned down, be it men, women, children, pregnant women, and the like. And so as I follow very closely this presentation that you have put together, I can't understand how we have all of these laws, but at the lower end of the scale, it seems that it's harder to get police officers to even do some sort of whistleblowing. You mentioned, good cops. I don't see those good cops intervening. I don't see those good cops crossing that blue line. I don't see those good cops following these laws that you so very eloquently stated and that I have learned about all 3 years of law school. As an African-American woman, I do not see this process working for my people at all. The hardest part is just to even get to the point where prosecutors are even willing to charge officers with crimes, with the things that they do. As a Black woman, I'm afraid to get pulled over in my car because I don't feel like I'm going to survive a speeding ticket, a parking ticket, or any other encounter with police officers, which is why I am here right now participating in this consortium. So I would like for you to explain how, in my capacity as an extern for the Public Defender's Office, can actually sell this idea that I don't actually believe in.
Well, when you frame it like that, it sounds impossible.
Well, I've been here 40 plus years, and it should not be impossible. I need to feel safe in my Black skin and knowing that all of these things that you have laid out apply to me too.
Well,
it doesn't have to be impossible.
Well, I mean, to be completely candid with you, I mean, I've looked like this for 54 years. So I instinctively and intuitively and experientially have understanding regarding some of the things you're making. I mean, I have no delusions. I live and work in the real world. And I know that we are nowhere near where we need to be. However, in some ways, I think it's a glass half empty or glass half full type thing. I mean, if you would have said 10 or 15 years ago that street cops in New Orleans were going to be intervening with their colleagues and preventing unreasonable uses of force, I think that would have raised some eyebrows. But yet we're seeing that, with the EPIC program. As far as, some of the other concerns that you raised, again, the problem is, I think, or one of the difficulties is that it's very difficult for a citizen to hold officers accountable when they feel that they've been treated poorly. You don't feel like there's any transparency. You don't feel like there's how to put this, like, there seems to be a lot of obstacles along the path to accountability. And I can certainly understand why community members feel that way as well. It's just very difficult, and I'm sure if you've read about bias-based policing, that it's very difficult to establish it without an admission, because you're looking at statistics and you're trying to draw reasonable inferences from them and stuff like that, and that can be very, very challenging. So a lot of times situations happen that you may know in your heart weren't done properly, and you feel like there's no way to hold the officers accountable. And I mean, I understand that frustration, because I hear it a lot of times from community members in different situations and things like that. The only thing I can tell you, and you might not find this a particularly satisfying answer, is that, this is the state of the law. This is the ideal. This is what, good cops are working towards. And, we didn't get here overnight, and we're not going to get out of here overnight.
Respectfully, I get that this is the state of the law, very much like slavery was the state of the law at the time. There is always excuse after excuse after excuse, and there is this demand for patience. And so from my station, I have to ask, how long is patient? And why is it that the aggressors are always in the position to determine how patient I have to be? As a mother, I have to say, I am concerned about my child learning how to drive, being pulled over, feeling afraid, and reaching for his inhaler because he's excited. That may get him killed. So yeah, it's the glass half full, depending on which side of the coin that you sit on. And so for me, it's not half full. We have a very long way to go. We're not even halfway there. So for me and people that are in my position, it's not a glass half full type of situation, respectfully.
Well, you mentioned, is there, and I don't want to put words in your mouth, is it that you don't think the legal structure is appropriate, or you think that there's a disconnect between the law itself and the way it actually plays out in community contacts?
The latter. Because I understand law to be what the way that it is implemented against various groups of people varies with, amongst those various groups. For example, you can have an upper middle class, white community have those laws, not be policed in the same way that, say, lower middle class or impoverished people are policed. You can have certain groups of people where, a student, a child can get caught with, marijuana, and they're taken home, and the police may talk to their parents, or, an open can of beer. There are some that are more policed than others. There are some that are more subjected to violence than others. There are some who can afford to have a voice in terms of, legal representation, and, others not have a voice at all. And so despite what all of these laws may say and how long they've been written, or the 50 years that we've been making process, at the end of the day, it's always the same problem for those that are at the lower rung or with a certain at a certain socioeconomic level, or that have a certain skin tone?
Well, I mean, I don't want to seem like I'm taking the easy way out, but I think some of what you're touching on goes beyond policing concerns and our societal concerns. And I don't think that,
A lot of what I'm saying is going right up against that blue wall, because the law is what it is. And sometimes those, good cops that you're talking about simply need to speak up. So it's not just societal, the police department does not exist in a vacuum. They are part of this society that we live in.
I think this is a really important conversation to be having, and I'm really grateful that it has been raised. I do think that this is a theme that is going to continue to resonate with the next two speakers that we have lined up. And so I wonder if everyone would be comfortable in pausing where we are now and returning to this theme with the additional information that we received from the additional speakers that we're anticipating. I think Ashley has brought some interesting perspective and information to the group, and that we will continue to add to this with the additional themes that have been identified. I think this is such a huge component of the work that we're hoping to undertake here. And so I want to ensure that we have appropriate time to unpack the entirety of the themes that have been raised. Does that sound fair?
and Deidre, I know we only have like probably another 10 minutes left tonight, but you have my contact information. Please feel free. I know you probably don't have any spare minutes, but give me a call anytime you'd like. I'm happy to talk to you.
Thank you, Ashley.
And apologies, I think I saw both hands raised at the same time. So Leslie.
Yeah, so my question actually went along what Deidre was asking. So I don't know if you want me to wait on asking it as well.
Let's bring it to the floor.
Okay, yeah. So first, I agree with everything that she said. And then second, Ashley, you did mention that policing in general is a hyper municipal sort of activity. However, I think we can all agree that policing in general, however, like across the whole nation, there's a commonality between that, which is the types of reactions that police officers have and who they assume is committing and not committing crime. And those assumptions lead them to believe what kind of response is necessary and appropriate at that moment. However, for example, when you were describing the facts on the Gardner case, if it was a different suspect, I can totally see how the police officer would have seen that interaction as normal. So how do you propose that each police department individually tackles those assumptions that are prevalent throughout the nation, which affect policing in our communities? For instance, here in San Antonio, 2 weeks ago, super close to me, actually, the 17-year-old Hispanic boy got shot like 8 times by a police officer. All he was doing was sitting in his car eating a McChicken. That's all he was doing. So how do you tackle this big issue if you break it down into very small squares when it's a broad issue that covers the whole nation and that is the same throughout?
It sounded like there was a whole lot of questions in there. Can you kind of break it down for me a little bit, Leslie? I'm sorry, you didn't lose me, but there's just so many questions in there.
Yeah, I guess just one question. What is one vision of reform that you could see to ensure that certain prejudices about people don't interfere with policing?
Well, I think that's a pretty tall order. I think, again, we're kind of getting beyond the scope of just a discussion about use of force. But I would think that to the degree there's a problem with bias in policing, there's a problem with bias in our society, because I think people who have these attitudes held these attitudes, their entire lives. I think sometimes we see situations where people, grow up and spend, 99% of their life only around certain types of people. And then all of a sudden they're put into a situation where they're law enforcement officers with people with whom they might not have had any type of interactions with those communities. I think, and I'm not a sociologist, so I'm probably not quoting this right, but I think there's something called contact theory. And that's the idea that the more you're around people who are different than you, the less threatening they seem. And I look back at my own experience in the military, because you go into the military and you're thrown into this environment with all sorts of different people, and you're around them 24 hours a day, 7 days a week, and you share hardships and you build camaraderie. And I think that is part of why I feel that the military is one of the most egalitarian institutions in our society. I think it's one of the places where people from underrepresented communities routinely are in charge of white people. And so I think that idea of just being around people all the time and interacting with them kind of smooths out some of the rough edges that we see. And I think that's one of the reasons that some police departments try to do community engagement with various organizations, and so that the officers can get to know the community members and the community members can get to know the officers in non-adversarial, non-confrontational situations. I don't know if you've ever heard of the National Coalition Building Institute out of Washington, D.C. A woman named Sherry Brown runs that. And they had a program, in fact, we did it in Pennsylvania, called Cops and Community, where they had a series of workshops for only the police, and they had a series of workshops for only the community members, and then they had a series where the community members and the police interacted. And those were very helpful. I mean, I don't want to sound like they magically resolved all the issues, but I think when you have people getting together in those non-confrontational, non-adversarial situations, that goes a long way towards minimizing some of the mutual suspicion and building, mutual trust.
I'm gonna throw it to David.
Can you hear me okay?
Yes.
All right, great. We had some audio problems throughout the day. But so you said something quickly, and I was thinking about it, and the more I was thinking about it, the more difficulty I had. So you were speaking about EPIC, and you said that the leadership decided that it wasn't effective to tell police officers to intervene to save the lives of, I think you said, suspected drug dealers and pimps, maybe, drug dealers and drug addicts. So it's better to tell them that they should intervene because their fellow officers will get in trouble if they use excessive force. And I thought, the more I thought about it, the more scary I thought it was. You can't convince police officers to intervene to protect the public. You can convince them to intervene so that their coworkers won't have to suffer through disciplinary procedures. And one way to understand that is that police officers value their own careers over the lives of the public. So do you think that's true? That police officers carry an us versus them mentality, where the lives of them aren't worth saving? And if it is true, do you think that's as big of a barrier to better police community relations than anything else?
Well, first, I'd like to gently correct you. I don't think that was quite what I said. But to your question, I think that we have seen numerous agencies try to break down the so-called blue wall of silence, to try and get officers to speak out about misconduct. And, if we just look around, we can see that that has not been particularly successful for many years. If if a shift in the focus gets us to the desired result, you know, I think that if, let's just say hypothetically, if I'm a police chief and I stand up in front of my officers and tell them about the importance of reporting misconduct and intervening in constitutional deprivations, and I talk about that, and I talk about that, and I talk about that, and I'm not really getting the results I want to see, if someone brings me a program and says, hey, this shift in focus is proven to work, well, maybe I'm not crazy about the shift in focus for the reasons you mentioned, but if it's getting the result we want, if we're getting officers to intervene when they're witnessing constitutional deprivations, isn't that a step in the right direction?
Yeah, certainly the lives of the public and saving lives should be everyone's priority. So anything that gets us there.
Recognizing we're a few minutes over time. I only see one other hand raised. Ashley, do you have a few more minutes?
Sure.
Awesome, thank you. Madeline.
Hello, thank you for taking the time to present to us today. I had a question about your theory about use of force policy and making it kind of a more flexible theoretical framework approach, and then your position on de-escalation. How would you propose that would work with loosening the use of force policies to make them more flexible and theoretical rather than being a real explicit policy, and then implementing the de-escalation policy with that kind of flexible approach?
Well, again, if I can gently correct you, I don't think that's quite what I said. However, if you look at that, I was actually advocating an approach where you would be narrowing the universe of situations in which the force could be applied. If we went strictly with the continuum as the agency administrative standard, where it said an assailant, an impact weapon, then we would run into a problem in that hypothetical I described, because I don't believe that the use of an impact weapon under those circumstances would be objectively reasonable. I would argue that that was a constitutional deprivation if that officer had used an impact weapon under the hypothetical we discussed. So what I was actually advocating there was a narrowing. It was more restrictive than the continuum would allow. You know?
Okay, thank you.
And tell me again, if you would, what was your question on the de-escalation?
I guess I misunderstood. I was interpreting that you wanted to create a more flexible policy for use of force, and that I was wondering how the de-escalation would fit into that, because I felt like what you were arguing for that was a little bit more structured and a little bit more, explicit policy driven. But that makes sense now that you've clarified. Thank you.
Well, this has been a really interesting and challenging conversation. So thank you, Ashley, for bringing this information to us and for responding to some of the questions and concerns that have been raised. I would like to hope that all of these conversations stay with the group. If there are additional feelings that have been raised that you'd like to talk to me about personally, I'm happy to do so offline and individually. I want to make that offer available to everyone. I think that this has been a really interesting first step into hearing from our external speakers and inviting outside perspectives into our conversation. So thank you all for bringing your honesty and respect into this space. And Ashley, thank you for your time and experience and expertise that you have brought to this group. I found it a really interesting and valuable conversation.
Well, I appreciate the invitation, and I appreciate you taking time out of your schedules. And like I said, please, I'm always happy to engage, even if it's just you telling me how wrong I am. So Deidre, I expect to hear from you. But please, all kidding aside, I'm happy to continue these discussions with anyone who would like to. And I'm also available as a resource if you have more technical questions as well. So thank you.
So thank you so much. As I mentioned at the start, next week we will be meeting at the same time and we'll be joined by Dr. Cynthia Lum. I will send a reminder email shortly, as well as a link to the recording from today, as well as a refresh on the presentation that was shared. Thank you all for being here. Have a warm and safe evening, and I'll look forward to seeing you next week.